Hi, and welcome to this first event in this year's Talking Animals, Law and Philosophy series. We are celebrating the 5th anniversary, actually, of the Talking Animals series this year, and we're really excited to have you all with us today. My name is Raphael Fazel, and I am the Executive Director of the Cambridge Centre for Animal Rights Law. For those of you who are attending the Talking Animals series for the first time, a quick note on the format. We're going to start with a 30 to 45 minutes presentation by our speaker. We then have a good hour or more for Q&A and discussion afterwards. Now, I would be grateful if you could use the raise hand function, which you should find somewhere on the bottom of your Zoom app, if you'd like to make a point or ask a question during the discussion. I think this will be preferable over using the chat function, just because it will allow you to ask your questions directly to our speaker. So in the discussion section, I'll just go through the different raised hands and you can ask your question directly. Until this point, I will be muting all the microphones so we can listen to our speaker. Now, with this out of the way, let me introduce our speaker of today. We have the great honor of having Angus Nurse with us. Angus is Associate Professor in Criminology and Sociology at Middlesex University, London. He was previously Lecturer in Criminology at Birmingham City University and a Research Fellow in the Law School at the University of Lincoln. Angus was also Investigations Coordinator and Legal and Data Protection Officer for the Royal Society for the Protection of Birds. His main research interests are in wildlife and environmental crime and the effectiveness of laws relating to the protection of animals and wildlife. Angus has published widely on these issues, including 3 recent books, Wildlife Criminology from 2020, Policing Wildlife from 2014, and a book entitled Animal Harm, Perspectives on Why People Harm and Kill Animals from 2013. In his presentation with the same title as that last book, he will today be exploring the topic of animal harm in more detail with us. Angus, thanks a lot for being with us here, and the floor is yours.
Thanks very much, and thank you for inviting me. Okay, so I'm going to talk for about half an hour, maybe 40 minutes, and then take some questions. And the focus of this talk is around some ideas on why people harm and kill animals. And I should give a bit of an explanation of the perspective that's being used here, because as Raphael said, my role is in criminology and sociology. So it comes from a criminological perspective. And much of the work that I do fits within what we would refer to as green criminology. I'm going to explain a little bit about this. I'm also going to explain a little bit about some approaches. And what I'm talking about today is part of a quite long-running research project into areas of criminality and enforcement of laws that protect animals and wildlife. And the green criminological perspective that this comes from is one where green criminology looks at study of harms against humans and the environment. And this includes harms against non-human animals. And it considered issues around crimes and harm committed by powerful institutions, which includes governments, transnational corporations, the military, and by ordinary people, and also looks at the notions of harm versus crime. And that's quite an important aspect of the work that I do, because criminology is frequently concerned with issues around crime and harm, with the harm focus being something that's quite important. So I'm going to give you a definition here of environmental crime, and we can apply this to a whole range of areas. But it talks about environmental crime as being an unauthorized act or omission, something that is contrary to the law, something that is subject to criminal prosecution and criminal sanctions. And it harms or endangers people's physical safety or health, as well as that of the environment itself. And it serves the interests of either organizations, typically corporations or individuals. This definition is taken from a book, an environmental crime book from about 2000. And you'll see immediately that one of the things that it does is that it situates environmental crime in the notion of something that is subject to criminal prosecution and criminal sanctions. You'll probably also immediately note from that definition that it talks about people's physical safety or health. It says nothing about animals. And so an immediate flaw of that definition is that it would ignore a whole range of acts committed against animals on the whole areas of abuse, wrongdoing, unauthorized behavior, etc., on the basis that the definition that we're looking at is one that effectively is based around human interests, might consider some interests around the environment itself, but that's often linked to harm to the environment, which is also linked to human interests. So as a starting point, it's problematic. And one of the things that green criminology does is it says we need to expand our notion of victims of crime. We also need to expand our notions of what we think should fall within the remit of criminology. And within that discussion, harm is often cited as one of the issues that we look at. Whether or not something is harmed, as opposed to whether or not something is classified as a crime. And within this, we're also considering the impact. So a core issue of criminology in the area of animal and wildlife crime is looking at the extent to which there may be activities that are legal, but which still cause incredible harm. Okay. Another issue just to raise here is how green criminology considers that there are different approaches to dealing with harm and wrongdoing. So we have a socio-legal approach, is probably the one that most people are familiar with, an emphasis on the use of the criminal law to resolve problems. A regulatory approach which comes in particularly when you're dealing with corporations. And this has an emphasis on regulatory approaches, self-regulation and the use of different types of regulators, not necessarily criminal justice bodies, but also NGOs, for example, for regulation. And then the third one is a social action approach, where we are emphasizing fundamental change, social transformation over a long period of time. Okay. Just going to pause at this moment to make sure that you can all hear me okay. Yeah, okay, good. Okay, so the Animal Harm Project, that's the focus of this talk today. And this is something that arose from my PhD research, or was part of my PhD research, and has considered. So started looking at this probably in about 2000, 2002. And for those of you that are students that are embarking on this kind of work, just to let you know, I'm not finished yet. So 20 odd years in almost, and we're still going. Okay. So part of the work looks at different aspects of animal abuse, if you like, how animals are harmed and our regulatory and social responses to animal harm. Noting that a lot of animal harm is legal, but also noting that one particular aspect of this project was around the way in which, despite the existence of quite a lot of laws providing for animal protection, good standards of animal welfare, if you accept that notion, and the ability to prosecute, impose sanctions, etc., for unlawful acts, we still have quite widespread animal harm and animal abuse in society. So what this project does and did is it looked at a whole range of issues about how we are defining animal crimes, who is committing harms to animals, the nature of those harms, and how we contextualize this idea of animal harm and animal abuse. And within this, it identified the fact that some animal welfare and animal abuse issues are not dealt with by mainstream policing agencies. So although police forces have had wildlife crime officers and engage in some activity, and this is no criticism intended here, some activity in enforcing these areas of law, we still have other organisations, non-governmental organisations, charities and pressure groups that are very active in animal abuse areas. So we have bodies like the Royal Society for the Prevention of Cruelty to Animals, who have a uniformed inspectorate that deals with animal welfare issues. You will see similar organisations. You know, there is an equivalent of the RSPCA in Australia. There are regional animal protection enforcement agencies in American states and so on. We also look at, also in this project, have looked at sort of changes in law and how pressure groups and NGOs are often involved in shaping the law. Some of you will be aware of campaigns that have been running, are still running, in relation to the notion of animal sentience in law, and also ensuring that post-Brexit, whenever we fully consider ourselves to be post-Brexit, we properly integrate European principles of animal protection within UK legal systems and elsewhere. And also where people have argued for changes to the law in order to provide for greater animal protection. An example of a success in that area is probably the Hunting with Dogs Act. But of course, although issues like fox hunting have now been, and hunting with dogs have now been, in one sense, resolved by the passing of legislation, of course, that legislation can be repealed and changed. And, you know, successive governments may decide that they no longer want to have a ban on hunting with dogs. And I anticipate questions about that later on. Another aspect, and one of the things that that's probably the focus of the next 20 minutes or so, is an examination of criminality and the causes of crime and the dimensions of criminal behaviour. Asking this question of, why do people harm criminals? Sorry, let's rephrase that. Why do people harm animals? And are the people who harm and kill animals one homogenous group? And one of the findings from this aspect of the research project, and that's set out in part in the animal harm book, is that that's not the case. There are lots of different explanations. People have different rationalizations, and people have different motivations. I'm going to talk briefly through some of the models that we developed in this project, and we'll doubtless pick up some more things in the questions, but that's one of the big focuses from this. And also, the project was a study of what might be considered to be a fringe area of law, in the respect that it's not what you would necessarily see carried out within mainstream policing activity. And that we do still rely to a certain extent on NGOs, on other mechanisms, rather than just seeing our mainstream policing agencies as being responsible for things like animal abuse. That's not to say that they don't deal with it, but in terms of, you know, the resources we give them to deal with it and the extent to which they're able to respond and have expertise, animal harm tends to be a kind of a fringe area that is sometimes looked at. Okay, so the project took a look at our definitions and the different ways that we contextualize animal harm. And whilst noting that a lot of animal harm and exploitation of animals is legal, it came up with this definition, which I appreciate is specific and also misses some things. But the focus here really is on unauthorized acts or omissions and things that essentially violate animal law. And as you can see from this definition, When we're talking about animal law, we're talking about a broad range of different functions that animal law has. Anti-cruelty legislation, conservation legislation, animal protection legislation, wildlife protection legislation, many of which contain animal protection provisions, but with the apparent paradox that animals can be protected in legislation and yet still be exploited, yet still can be killed or taken for certain purposes. What this definition also does is it identifies one of the flaws in the earlier definitions, which is not everything that we might look at as a form of animal harm or animal abuse is dealt with by criminal prosecution and criminal sanctions. Some animal issues relate to the notion of animals as somebody's property, and so civil sanctions are used. So if you stick with a solely crime and criminal law definition, you will let out a whole load of things where it might be challenging to actually apply the criminal notion, but a civil sanction might be appropriate. There are problems with this, and I have no doubt we will get onto those when we get into the Q&A. But it also notes here this idea of redressing the harm that is caused to the animal. So that is the focus. It's the harm that's caused to the animal rather than the focus on perhaps an individual act. There are many aspects of wildlife and animal legislation that talk about a prohibited act, but perhaps diminish the welfare problems when you think about the harm that's caused to the animal. So this definition here includes the notion of criminal and civil sanctions. And it talks about harm, injury, killing, removal from the wild, possession or reducing into captivity, the sale or exploitation of animals or of products derived from animals, and also, to try and be as comprehensive as possible, it also includes the notion of causing physical or psychological distress to an animal. So it's quite an expansive definition used in looking at the way that the law is enforced, looking at the way that criminality manifests itself. But even though it is quite expansive, it's not exhaustive. And doubtless there will be things that we might come back to in looking at this in terms of what it doesn't cover. Okay, so that is the working definition from a criminological perspective of animal harm that's used in the research that I've done. And it's intended to basically say, look, where animals are harmed or injured or cause distress, this is animal harm, and there should be some mechanism for redressing the harm that's caused to the animal, whether that harm is direct or indirect. Okay. So that's one of the conclusions, if you like, of the research, is that we need a broader definition in relation to illegal acts. Okay. Legal acts is a whole other issue, but for for the purposes of what we're talking about here, we're talking about illegal acts. And arising from this, the research has also looked in detail at who is causing harm to animals and why. And this aspect of the research took place over a couple of years, looking at prosecution data, carrying out interviews with NGOs. First round of interviews took place, I believe, in 2001, 2002, and have continued since. It has involved looking at how police and enforcement agencies interpret and analyze criminality and the types of activities that are being prosecuted. And from this, it identified that rather than there being one type of offender, one homogeneous group of offenders, there are several others. There are several different types. And again, although this breaks it down into 5 broad categories, this may not be exhaustive to cover absolutely everything. The focus of part of this research was around wildlife offenders, but it's been applied to other types of animal offender as well. Okay, so our 5 models here of different types of offenders. I'm going to talk a little bit about the rationalizations and motivations of these different offenders as well. The one we're probably most familiar with is what we might call a classical or traditional offender. Somebody who harms or kills animals for personal benefit or direct financial gain. And when we talk, for example, about wildlife trafficking, that's the type of offender that probably garners the most attention from academics, policy people, criminologists, and enforcement people. The person who is exploiting and trading in wildlife because they're going to make money out of it. And that tends to be, that's not the only category. And we've revisited some of this in the wildlife criminology book that came out earlier on this year. But that tends to be the one that people are most familiar with. But we also identified that there are other types of offenders and other motivations for people injuring, harming, killing animals. This includes people who have economic reasons for doing so that may not necessarily give them direct personal financial gain. People who do so for links to masculinities and an expression of their male identity. There are people who do so for what we might refer to as hobby purposes. And this can involve things around engagement with animals where there is no financial motive. And then the final one is what we're terming stress offenders. So people who their victimization and exploitation of animals is in part a response to their own victimization and their own engagement with problematic areas of their life. I know there's a couple of things in the chat, so I'm just going to very quickly check those. Okay. So these categorizations are a combination of the research that I did over the years, and I'm still doing, around looking at different types of offender, different types of motivation, and so on. And some of the things that you will find in some of the literature which explains different ways of offending. Part of the problem for policy tends to be that it treats most offenders as if they are the model A, the classical offender, the traditional offender. So somebody who's making a direct profit out of their activity. However, the reality is that there are some people who, rather than making a profit, actually spend quite a lot of money to actually, engage in the activities that they do, in which case that notion of they're doing it for profit may not necessarily follow. And I will explain that as I go through. So I have already briefly explained the Model A offender. And in the case of wildlife crime, for example, this is profit driven. People trade in things like rhino horn and in the skins of rare animals because they can make money out of it. And from one perspective, one theoretical perspective, there's a rational choice to do this. People know, for example, that some species of wildlife and even wildlife derived products like caviar can sell for high quantities. And things like rhino horn and bear gallbladders are used in some forms of traditional medicine, and so they're highly prized, as are pangolin scales and so on. And so these things attract a lot of money, and so in one sense it's considered to be, from a rational choice perspective, if you trade in this, you make lots of money. And we've seen evidence, for example, of organized crime becoming involved in wildlife trade, because in one sense, it's a low risk, high return form of crime. If you are trading in weapons, guns, people trafficking, you are aware that you are likely to be the target of a fairly concerted policing and sometimes transnational policing effort aimed at your activities. Whereas the reality for some forms of wildlife crime is that they might still be considered to be a minor or technical crime. So less attention is perhaps given to the illegal exploitation of wildlife than might be given to the exploitation of people. And, if you look at definitions of international criminal law, you will find that, human trafficking, crimes against humanity, genocide, etc., are readily contained within things like the Rome Statute of the International Criminal Court. But you might struggle to find an international criminal law mechanism, a comparable mechanism for animal and wildlife crime. And there's actually a campaign going on at the moment to try and redress that issue. And the rationalization for offenders may be that wildlife is simply a resource to be exploited. And there are all sorts of complex notions around, people's right to use and exploit wildlife. And within this, you do see organized crime groups that engage in wildlife trafficking and the exploitation of animals. And when we're talking about organized crime, I've just put this in just to sort of identify that there are different aspects of organized crime. So when we think about organized crime, we may automatically think of mafia style groups and those kind of organized crime organizations. There is an element of that, but there are also different types of organized crime groups that are involved in. And here, this is drawing on the work of Zimmerman, who identified essentially 3 different levels. So at a lower level, you might have groups of farmers who sell wildlife and animal products illegally in order to supplement their income. In the mid-level, you might have mafia-style groups that are engaged in purchasing and selling on and procuring wildlife for profit. And then at the high level, you do have perhaps what we might think of more as the organized crime groups, major international smuggling rings who might also be involved in other illegal trades. And when I was doing my PhD research, I was informed by some of the enforcement people that I interviewed that yes, there is clear evidence that what's happening is people are using the same smuggling routes as they use for other illicit commodities, because once they have the smuggling routes set up, once they have the infrastructure, it's just another resource. And whilst that might be something that's abhorrent to some of us, if you think about it in the context of once you are engaged in that activity, it's another trade, it's another product. Okay, so evidence of organized crime being involved. And that again fits our model A, our people who are doing this for profit and direct personal benefit. Our model B is a little bit more problematic. So you will see, for example, wildlife and animal crime that's driven by economic and social pressures. Again, you have the notion of wildlife or animal abuse being considered to be a minor or technical crime. But you can have, for example, external factors such as keeping employment. So examples may be, and these are not by any means comprehensive examples but there's quite a lot of detail about this that we've gone into in the published works. People who are involved in what are otherwise legitimate industries, but where there are animal welfare or animal protection concerns that are ignored because of pressure that is brought to bear by an employer. Okay, so we can see, for example, animal welfare problems in sporting industries where animals are involved. We can see in food production industries where, every now and again, there are problems that are involved with non-compliance with animal welfare standards, and that there may be internal and economic pressures to bypass these in order to have a high yield of product. So full compliance with legislation might be problematic. And in some of these areas, you will see people who are otherwise law-abiding and may cooperate with police, but do not cooperate within their area of animal offending. So, for example, there have been discussions around the extent to which, in some aspects, and I stress some aspects of the game rearing industry, there may be problems with, there are reported problems and have been reported problems of unlawful killing of wildlife and non-compliance with wildlife protection legislation. And the rationalizations that sometimes come out in relation to these, where you have somebody engaged in a law-abiding activity, but who's driven by economic and social pressures to abuse or fail to comply with animal protection legislation, it can be a whole range of things. The notion of this being a victimless crime is unfortunately still prevalent, still comes out. Complaints that what we're talking about is a technical offence or an offence of a minor nature rather than something that is serious. So, you know, an example might be if you're working in an area that does involve the killing, the legal killing of animals, but you have failed to comply with the regulations, that might be passed off as, well, it's a technical offence. We didn't follow the rules. We didn't, you know. So those are the kind of things that we've looked at. And then a kind of dismissal of the enforcement approach as well. You know, arguments that resources should be targeted elsewhere, that there is real crime going on. This should not necessarily be something that's looked at. Model C. Now, this relates to masculinities, and it involves the idea of wildlife and animal crime being forms of identity expression and reinforcement, and an exercise of power. And these can be linked to ideas of stereotypical male behavior or historically stereotypical male behavior. And they can be linked to other things like sport or gambling. So, for example, dogfighting. And there are examples of the acceptance of this kind of behavior within certain subcultures. There's American research, for example, that looks at the nature of dogfighting and cockfighting as existing within certain subcultures where this behavior, also these activities, still continue, even though they are ostensibly unlawful. They've been prohibited by legislation, so they do still continue within some areas. And there are examples, you know, of there's an example of an American footballer, for example, who ended up. This one is public, so I think I can name the person. So Michael Vick, an American footballer, ended up being prosecuted in relation to dogfighting issues, and was still able to return to the NFL as a football player, despite having this form of offending as something that was acknowledged. And in one sense, it could be argued that this, you know, reinforces the idea of that type of masculinity, you know, and some kind of, you know, sort of bad boy cultures even. Rationalizations here are often linked to ideas of precedent or tradition. When the attempts were made when the Hunting with Dogs Act was being introduced, that is one of the arguments that was raised, that this is a historical or a traditional activity, not necessarily commenting on that particular aspect of it, but in relation to issues like dogfighting and cockfighting, in some of the research that we looked at and some of the prosecution work that we looked at as well, we did find that these arguments came up, that things were contrasted as, you know, town versus country, the imposition of, if you like, liberal ideas around nature being imposed on people with a tradition of these kind of activities. So just raising that as the types of rationalizations that come up. And the response to these often involves a kind of serious or organized crime response. So dogfighting is sometimes dealt with through techniques of surveillance, undercover work, gang infiltration, and an acknowledgement that the individuals involved are sometimes sort of dangerous individuals, and that there's an element, this is not a kind of judgment call, but there's an element of the nature of this as kind of group activities that are not necessarily easy to investigate and prosecute. Okay. Fourth model is quite a hard one to explain, but it's around wildlife and animal harm and offending as kind of being hobby based, and at times it involves no real profit motive. So the hoarding of animals, for example, can sometimes be linked to notions around acquisition. I'm going to hope everybody knows what I mean when I say egg collecting. And if not, I will pick that up in the questions. But people who collect wild birds' eggs, for example, and essentially collect the eggs for their own private collections. There's little or no evidence of them changing hands for money. There's no real profit motive attached. It's, if you like, it's an acquisitive kind of behavior. And rationalizations here are often around denial of criminality and displacement of blame. So people who are, for example, involved in hoarding animals, again, in some of the research that's been done around this, some research links this to almost like a form of mental illness, a form of kleptomania. In other cases, we are talking about people who are perhaps well-meaning, but they collect more animals over and above their ability to cope. And in the process, this then causes animal harm. Okay. And the final category, which I'm going to say a little bit about, I think I've got 5 minutes or so to cover this, is around people whose offending in relation to animals, the reasons why they harm and kill animals, is often linked to their own vulnerability and their own victimization. And it can be an indicator of problematic power relationships within families where the offender may themselves be a victim. And some of the work that's been done around this has looked at, for example, the reasons why children harm animals within a family dynamic. And this links to where the behaviors of children or the understanding of children can come from observing behaviors elsewhere within the family, including domestic violence and pet abuse. And that can, doesn't always, but can have the impact of sort of normalizing a propensity for interpersonal violence, and their own abuse of animals can be a reaction to what they are experiencing within the family. So this raises the question of whether or not children and adolescents involved in animal abuse are themselves victims, and the extent to which their animal abuse is an indicator of other forms of existing interpersonal violence within the family dynamic. Now, there is quite a large literature around the links between animal abuse and later interpersonal violence, future violent offending, which would probably be the subject of a whole second talk. But just to highlight the idea that this is covered in the literature, it's covered in different aspects of the research. And one of the things to look at here within this notion of animal abuse as a form of stress offending is control and the nature of power and hierarchies within the family. Often this means that children are at the bottom, and we're frequently talking about male offenders, male individuals with the bulk of the power at the top, who are significant factors in interpersonal violence, significant factors in animal abuse, and links to the notion that animal abuse can be a form of control by, in one sense, the threat of abuse of an animal or engaging children and vulnerable family members within the abuse of animals as a way of controlling them. Okay, so those are our 5 categories. I'm going to wrap up with just a quick comment around the prosecution of environmental crime and animal and wildlife crime. And one of the issues that I hope these categories identify in this explanation of the different motivations and rationalizations that people can have is that it prevents a challenge sometimes for the prosecution, so the investigation and the prosecution of offences involving the abuse of animals. Now, I've taken part of this from a paper and a speech by Lord Wolfe, formerly one of our most senior judges, back in 1992, where he talked about the problems of prosecuting environmental cases. And I have applied some of this through the research where we've looked at some of the challenges of prosecuting animal cases and wildlife cases as well. And it includes some issues around the lack of available scientific support in order to prove some of the aspects of animal harm. We are obviously helped by this in relation to legislation like the Animal Welfare Act 2006, which provides responsibilities in respect of a duty of animal welfare. So in one sense, in relation to companion animals, this becomes a little bit easier by, for example, being able to use veterinary evidence, hopefully, to prove the harm and suffering that an animal has experienced. Harder when you're looking at wildlife crime for a whole range of reasons around the remoteness of where some of these issues take place, the lack of available scientific support in some areas, and so on. This also identifies some issues around the required specialist wildlife and animal law knowledge of prosecutors and investigators as well. And also some issues around perceived loopholes in legislation. And there is an inconsistency in different parts of animal and wildlife protection legislation. We have a project going on at the moment that's looking at some aspects of this and identifying, the need for consistency. And in looking at sentencing, for example, one of the things that we have noticed within this project is that when cases are prosecuted, in many areas, particularly in wildlife crime, the sentencing options tend to be at the lower end of the scale. And there's probably a complicated debate around why that may be the case. So I've gone slightly over my allotted time, but I've hopefully covered at least an overview of different aspects of the research, and to kind of sum up this idea that when looking at wildlife and animal offenders, we need to look beyond what we might think of as the traditional notion of there is just one offender motivated by profit, but there are other aspects that come into it. And so I raise these questions or raise these points at the end around whether or not we should look at animal crime and wildlife crime as part of mainstream crime. Also looking at this idea that it should attract a holistic justice response. So it shouldn't be just seen as an animal welfare issue or a wildlife issue, but should be linked to other aspects of offending, particularly in the idea of building an offender profile, and to think about also aspects of the global significance. When we look at something like wildlife trafficking, it often involves trade across international borders and happens on a global scale. So that's something that may require looking at in a little bit more detail. I was going to say a little bit more, but I'm over my time, so I will stop there and hold for questions.